Hello, my name is Major Mike Webb, and I hold the unique distinction of having the only case brought against the lockdowns in the Commonwealth of Virginia to proceed to a trial conference against the nation's only physician serving as governor, a case that no person running for governor ever even brought during what has often been called an unprecedented once-in-a-lifetime pandemic crisis for which no person could have planned. But perhaps within the view of an omniscient God, it is of at least probative value that I hold the unique distinction of having served as the most junior commissioned officer to have ever served as the operations officer for all Army Strategic Counterintelligence in the continental United States, which, as you may imagine, has at least some tangential connection to activities in what is referred to as intelligence oversight, like waking up a magistrate to get authorization for a wiretap, or applying the laws regarding the protection of personal liberties in the confrontation with an overriding state interest. But by what I can only describe as a certain providence or uncommon luck, I did not arrive there just because I was black, without some preparation. For prior to that assignment, I had served as an enlisted soldier, as a legal specialist for a Ranger battalion, a unique position under a commander in the grade of lieutenant colonel, vested with summary release authority permitting him to remove soldiers from the Ranger regiment for their failures to attain or sustain the high standards in that special operations community, but also vested with what is referred to as special courts-martial convening authority, a judicial power generally reserved for a full colonel in command of a brigade, group, or regiment-sized military organization. And prior to that, in my youth, I had been the childhood protege of a legendary criminal defense attorney, Raymond Brown, who had a list of high-profile clients to include the defense during the ab-scam allegations against Camden Mayor and New Jersey State Senator Angelo Ericetti, who had been portrayed by the actor Jeremy Renner in the movie American Hustle. Defense of Hurricane Carter, who had been portrayed by Denzel Washington in the movie, and who had served as the defense counsel in the Pachinko case, an espionage case not unlike the famous Rosenberg trial. And there has been a little litigation during the course of a pandemic that has found as many as 24% of even atheists praying for an end, at least back in the beginning of the pandemic, raising claims in the courts in defense of religious liberty. It's often talked about by many pundits on social media, but none of whom ever brought a case, which were generally opposed by attorneys, state attorneys general from the several states, offering at least a pretext that they were great men of faith as well, but arguing extraordinary circumstances and the authority of science on constitutional grounds, with many references to the case Jacobson v. Massachusetts, a Supreme Court case that was decided in 1908 regarding the intersection of a liberty interest with the authority of the state to mandate vaccinations against smallpox, a validated 60% infectious, highly contagious pathogen, a point of distinction with regards to a novel coronavirus with no stated attack rate by any government authority, nor an infectious dose even determined during vaccinations trials for purpose of assessing its efficacy. And so, with a push for vaccinations produced rapidly under Operation Warp Speed, which permitted pharmaceutical companies to take full advantage of the emergency use authorizations granted by the Food and Drug Administration, while also securing for themselves release from liability for the next few moments, having reviewed preparations taken by your adversaries, if you are persons of faith, it may be informative and timely to discuss the legal strategy or lack thereof in the religious community in making provisions for their hereafter, at least as far as the end of the pandemic is concerned. And our issue for consideration might be stated jurisprudentially by the question as to whether post-pandemic you hold a sincerely held faith belief to survive a summary judgment in court. Judgment Day. At the outset, a proper framework for those unfamiliar may be proper, and perhaps the earliest recorded primary source for religious liberty may be found in what lawyers refer to as the legislative history, which those in jurisprudence may examine to provide a deeper comprehension of the words contained in statutory and constitutional provisions, such as the freedoms of religion that were expressed in the First Amendment under the Free Exercise and Establishment Clauses. And most often in understanding matters like the separation doctrine, most legal scholars don't just say what they think in their head, but will refer to Federalist 51 as written by the Virginian James Madison, where he opined a role for the churches as a part of an extra republic to form the individual consciences of citizens in the whole. And in a frequently cited case by defenders of religious liberty, in the media at least, but rarely if ever advanced in a legal argument in court during the pandemic, the Supreme Court, in the case of West Virginia State Board of Education v. Barnett, decided in 1943, had stated, at least in dicta, that if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. You cannot legislate morality. You cannot legislate political correctness. Notwithstanding that clear guidance from the nation's highest court, as stated in Stanley v. Georgia, a Supreme Court case decided in 1969, whatever the power of the state to control public dissemination of ideas inimical to the public morality, it cannot constitutionally premise legislation on the desirability of controlling a person's private thoughts. For anyone who became a litigant during the pandemic, it was a once-in-a-lifetime opportunity to raise claims under at least the First Amendment, that first liberty of freedom of religion. Like the big wave finale for Bodhi, the Zen master leader of the surfing clan, humming serenely with the wisdom of the waves, portrayed so memorably by Patrick Swayze. And Bodhi probably would have been a litigant during a once-in-a-lifetime pandemic because, if you may recall in one of his quotes, that spiritual, even if not religious, surfer dude says, "Yeah, I know, man, ain't it wild?" That's what makes it so interesting. You can do what you want and make up your own rules. Why be a servant to the law when you can be its master? But in pandemic, the courts of record clearly reflect that most of us are not quite the badass Zen master surfing clan leader who we may have thought in our heads we were just a year before. And there is no Johnny Utah out there telling anyone not to worry about you getting away because you are not coming back. But for those who went to court during the pandemic to fight against the closing of the doors of the church, they, at least, are probably intimately familiar with the statement of the rule of law as expressed in a New York 2004 case in the federal courts in the Southern District of New York, Cardew v. New York State Department of Corrections Services, brought by a Jehovah's Witness, Robert Cardew, where that court, quoting from the 1988 Second Circuit case, Farid v. Smith, says that in determining whether there is a violation of the Free Exercise Clause, courts must assess, 1, whether the practice asserted is religious, which might be designated in essential proofs as 1A, in the person's scheme of beliefs, or requirement to prove 1B and 1C, whether the belief is sincerely held. 2, whether the challenged practice of prison officials infringes upon the religious belief. And 3, whether the challenged practice of the prison officials furthers some legitimate peniological objective. You may glean from the statement of the rule of law by the court in the quoted language from the Farid case as applied to the plaintiff Mujahid Farid, a man in prison and bona fide sinner, just as you may glean from the case caption that plaintiff Robert Carter was a man in prison and bona fide sinner. And if you were required to brief this case in the first year law school class, these might be pertinent facts that you might decide to raise when called upon to answer a Socratic method interrogation, which provides an intriguing argument brought under the Free Exercise Clause, because very few might argue that either of these gentlemen were persons without sin, and there is an ancient rule in the laws of equity that survives even today in American courts, that one must enter into a court with clean hands under the clean hands doctrine. Mujahid Farid was in fact a prisoner at Attica, the place of the prison riots that stirred Al Pacino's character to begin chanting Attica, Attica, Attica in the film Dog Day Afternoon, before the cries of pandemic became Black Lives Matter as the expression rally progressive cry of in vogue. But we only know of Robert Cardew from the facts recorded by the Federal District Court in the Southern District of New York that he had also been incarcerated in the New York State Correctional System. These prison cases are always intriguing because they represent the powers of the state in restriction of liberties in the most extreme circumstances, and hence are considered the most important by the courts, where an overriding state interest often subordinates an individual claim of a right to certain liberties. So in other words, you had better get a really good lawyer to take your case if you are in prison, or you will probably not prevail. And it is known that Mujahid Farid had sufficient resources or connections to obtain the legal services of the large defense attorney firm with over 1,000 lawyers of Weiss, Rifkind, Wharton, and Garrison, a national law firm with a progressive reputation based in New York City, while Robert Cardew, an adherent to the Jehovah's Witness faith tradition, represented only himself. But the most intriguing thing in comparing these two cases on the fact is the court's application of the rule under the Free Exercise Clause, as one reviews the pertinent fact for these incarcerated sinners and the dispositive consideration in the restatement of the rule regarding a sincerely held faith belief, which may well have dictated the outcomes in those jurisprudential matters. If one were to grant license to prejudice, one might assume that Mujahid Farid, simply by the sound of his name, had to be an adherent to Islamic religious beliefs. But your colorblind judgment would be wrong, at least with regard to what had been entered in the records of the court. And one might further assume that when he brought his case to the courts under the Free Exercise Clause, he had averred some traditional devotional worship practice within the Islamic traditions of belief in his complaint against the correctional facilities at Attica Prison. Whereas the court had specifically found the prison officials had denied him the opportunity to have a chaplain review his complaint, had not even had his formal complaint considered by the prison officials. But a closer examination of the facts that gave rise to these apparent deprivations of religious liberty and an alleged sincerely held faith belief indicates that Mujahid Farid was a prisoner at the Attica prison who had come to court to recover some confiscated contraband items, such as a tape player, some Everlast boxing gloves, a clock, some books, and some tarot cards, all of which items were delivered to this person in prison while he was incarcerated in a manner indicative of surreptitious probing, a preliminary stage consistent with the doctrinal actions of terrorism, and a test of the prison's contraband prohibition policy. And in his claim, brought under the Free Exercise Clause, he had filed pleadings under penalties of perjury that his tarot cards that he had received as a gift in prison were a devotional practice in his sincerely held religious belief. And indeed, before the state trial courts, before the matter was brought on appeal, that federal court stated on December 30th, 1983, a long time ago, the state court entered judgment for Farid, holding, one, that Farid was entitled to possession of the tarot materials. Two, that the policies and practices denying him the materials were unconstitutional. And three, enjoining Smith from interfering with Farid's efforts to obtain the materials. However, despite the order of that court and in apparent contempt thereof, the tarot books and cards were never turned over to Farid. And having prevailed in state court in defense of his claims of religious liberty, Farid was not satisfied because he was still yet deprived of what he had called his religious property in the form of these tarot cards and two books on the topic, and therefore decided with his powerful New York law firm to raise his objections on appeal, not through a writ of mandamus in the state courts to compel the prison to simply obey the court order that had been handed down, but rather in a new action filed in the federal court system. And the general rule applied on appeal in courts as articulated in the Federal Rules of Civil Procedure number 60 is that an appeal from a final order may only be brought for review in appeal in the event of an adverse ruling. And at least with regard to his claim of right of record, Mujahid Farid had prevailed in his case in the state court, brought to redress his religious rights, surviving a motion to dismiss. But an important thing to remember, particularly in this case, is that in a motion to dismiss, the court only tests the sufficiency of the pleadings, and all allegations and averments are accepted as true, so that the only requirement is to plead sufficient averments to establish a justiciable controversy for that court to decide in a matter upon which it has been granted authority under law or in equity to provide a remedy to redress an actual and direct injury. But rather than going back to that state court, Mujahid Farid, armed not with the armor of God, but with the aid of a large criminal defense law firm, decided to make a federal case out of his deprivation, bringing a suit to recover his property in the federal district court. And having been defeated in the district court, he continued to the circuit court of the Second Circuit on appeal. And so the court record says on appeal, Farid also claims his deprivation of the tarot cards violated his First Amendment right to freedom of religion. We do not believe, however, that Farid has properly pleaded or presented any evidence that the deprivation of the tarot cards violated such a First Amendment right. Think about this. A powerhouse progressive law firm representing a person of no apparent financial resources of his own, who had received while in prison several gifts to test the contraband prohibition, had prevailed in a claim of his rights in the state court, but with insufficient skills amongst criminal defense counsel to plead sufficient facts in federal practice to present a justiciable controversy, are all facts giving rise to a reasonable suspicion. And the court concluded because Farid has neither alleged nor submitted any proof that he sincerely holds to any religious belief that mandates the use of tarot cards, we conclude that summary judgment was appropriate on the free exercise claim. Mujahid Farid had prevailed in his crafty argument to avenge his rights in the trial court, and you may have applauded. But on appeal, since he had avenged his rights, but not claimed his reward and properties through the return of his cards, apparently the outcome suggests that he didn't know when to hold, know when to fold, know when to walk away, and know when to run, because that court was not apparently persuaded by a traditionally progressive court with its sincerity. And a motion for summary judgment was granted to defendant Harold J. Smith, superintendent at the Attica State Correctional Facility. Anyone examining the facts of the case, as well as the procedural history under a strict scrutiny standard, might conclude that the court was certainly not in error, rejecting the religious liberty claims of Farid, if only for the simple fact that he had made the peculiar election to suddenly depart the state courts, where he had indeed secured his right to the subject's right of possession for the tarot card. But rather than exhausting any administrative means available to perfect that interest, possessory interest, or even returning to the state court upon petition for a writ of mandamus to compel the warden at the Attica State Prison to return that which the court had already claimed was his by right, and even granting deference to his claim of religious belief, he decided with no further evidence of a sincerely held faith belief to depart that legal forum, a bird in hand. A bird in hand, often worked two in the bush. He decided to depart. That legal forum and into federal court. And nor did that generally progressive court bar his claim on the preliminary grounds of a failure to exhaust all administrative remedies, as courts are wont to do, but rather hearing the case and laying down that defining rule binding on all, and with which you must now contend in a post-pandemic world where leaders of faith voluntarily had closed their doors, while over 20% of former regular worshipers chose to return to their sincerely held faith beliefs after the pandemic, during a time when Bible reading is at its lowest point in history. And so the dispositive question is, when you close the doors of the church, have you made your provisions for the hereafter? Post-pandemic, can your faith survive under Farid a summary judgment? If it could not survive a novel coronavirus alleged to be bigger than God that closed the church at Easter. Post-pandemic, can you plead to a court under penalty of perjury an affirmative answer when that judge over the matters of this world, and not even the eternal, asks, had you made your decision for Christ? On summary judgment, can someone say to you that thou art Peter, and upon this rock I will build my church, and the gates of hell shall not prevail against it? On summary judgment in a pandemic time, can you tell a Paul who had warned the church at Rome, and be not conformed to this world, but be ye transformed by the renewing of your mind, that ye may prove what is that good and acceptable and perfect will of God? On summary judgment, can a man who ran a good race, fought a good fight, and kept the faith in his last days of life find a blessed assurance in you to write, I charge thee, therefore, before God and the Lord Jesus Christ, who shall judge the quick and the dead at his appearing and his kingdom. Preach the word. Be instant, in season, out of season, reprove, rebuke, exhort with all long suffering and doctrine. For the time will come when they will not endure sound doctrine, but after their own lusts shall they heap to themselves teachers having itching ears. And they shall turn away their ears from the truth, and shall be turned unto fables. But watch thou in all things. Endure all afflictions. Do the work of an evangelist, make full proof of thy ministry. For I am now ready to be offered, and the time of my departure is at hand.
And so here is the truth. My name is Major Mike Webb. And by God, I am running for governor of Virginia. I ask every Virginian and every American true to, like the motto of the infantry, follow me, and we shall overcome. Honest.
And y'all come back now.
Yep.
This advertisement was authorized by Mike Webb.
And y'all come back now. Here.